And so 2 of those are bad.
Yeah. I had someone once tell me, and I just remember this rhyme because it always sticks with me, is settlements make the money flow, trials make the blood flow. I love trying cases.
I do too.
I know you love trying cases, but that's not always the best option for our clients.
That's right. Our commitment is to do what's in the best interest of the client, and sometimes it's to settle.
Yeah, absolutely. Well, unless you have anything to add, I think that pretty much...
Side deal, if we have talked to you about our number, we're not going to lower it just because the mediator called us out in the hall. We may not settle.
Absolutely. So let's talk about moves at mediation. So there's a lot of tactics that we can use at mediation.
Tell them what you mean by moves.
Well, so when we start out, we're going to start out at $11 billion and the defense is going to start out at 0 and we're going to settle somewhere in the middle, right? And our first couple of moves are going to be pretty small usually, and their first couple of moves are going to be pretty small. Does not get additional authority, which may be necessary to settle your case, unless they go to mediation. So even though it can be worthless, the whole process, because Rafe and I could simply exchange numbers if we were opposing lawyers, it is something that triggers additional authority. So just see it that way. See it as part of working the process to get your case resolved.
Let me tell you what I've told myself, Chris, to justify mediation.
The case is going to trial. I have clients that leave a mediation that's unsuccessful and say, I guess we're going to trial. But could be. But don't think that's certain. It certainly is the case, because there's still ample opportunity to settle a case. Some have settled, on the courthouse steps. Some have settled after a week of trying the case. And I'm not advocating for settlement at all times. I'm just saying sometimes it is the best option. I don't necessarily want them to hear what you and I are going to talk about. Because again, remember, their goal is to get the case settled. So if you and I are discussing and we're saying, well, I guess I would take X, but meanwhile the mediator is only hearing Y from me, and Y is a much higher number, I want the mediator to think that, because his goal, and he knows that I'm doing this, but we don't want him to know our number, his goal is to get it resolved. And meanwhile the defense is doing the same thing. They're just kind of making arguments to the mediator to try to bolster your case. And those are moves. But there's also more thought out moves that sometimes happen in the mediation later on, and that's brackets. For example, if we're at 800,000 and they're at 100,000, and we just can't seem to get any movement because we're making $5,000 moves, we'll say, all right, we'll go down to 600,000. What did you see? What have you seen is the attributes of the lawyers in the cases that are the most successful at mediation? And he told me it's those who are the most patient. I believe it.
I think that's a good example. My answer to how long it takes as long as it takes. I've had mediations last an hour. I've had them last let me just say that I've had them last 5 days, and it was worth it for that mediation. Now, we didn't sit in a room for 5 days. We left after the first day about midnight, and we were on call and mediated that case for 5 days. So it takes as long as it takes. But what I want to say about the time factor is that what else is more important? Can you not spend all day today to resolve this case and not have to miss work again, not have to make exceptions for your daycare, not have to be worried? My rule is, if I got to be there, I want you to be there.
Yeah.
The mediator is going to require you to be there because you are the plaintiff and you're the only one that has authority to settle. Now, under extreme circumstances, I might could get you on the phone and get your authority, but the mediation really is not for the lawyers. It's for the litigants. And so if you're not there, you're not feeling the whole effect of what's going on in the room. You don't know what the defense strategy.
And then we will, and you'll have been prepared for this, we'll ask you to just kind of say how the wreck or the termination or whatever affected you. So it will be necessary for you to speak at that point. Now, by all means, if you don't feel comfortable about that, we can discuss it, and you don't absolutely have to. I mean, later at trial, you'd have to speak anyway, so I kind of feel
Good
like
practice.
it's a good practice, yeah.
Can I add one thing?
Yes.
I won't waive opening joint.
Here to talk to you today about mediation. So, if your case is going to mediation, that means that you've probably gone through written discovery, depositions, and trial is on the horizon, and we're giving it our best shot at getting this settled, right?
That's right. Mediation's an opportunity for the client to take control and control his own destiny.
Absolutely. The decisions you make here can mean that your case goes to trial, and maybe if you'll come up to $300,000. That way, we're both moving significant amounts to try to get the case settlement moving, the mediation going, because sometimes it just takes that kickoff thing, and then it's like, okay, we've got them below the like scare us to death. You know, this is what the defense is thinking. We've got them below the scare us to death number, and we're thinking, well, we've got them at least to a point where it's starting to look a little more appealing, and those are brackets, and those are you on. By that I mean, you know, we demand this, and they say, well, we'll come up 3,000, and say, then we're only going down 2,000. And it's a lot of psychological warfare, kind of, to, it's almost like chess, right?
It is a lot. I was just thinking that.
Yeah, so you're kind of trying to see where the other side stands. And with each move, typically, you provide counter arguments about like, well, but your client admitted in deposition that he had been drinking or willing to settle the case, but you've compelled the defendant to be there, and the defendant is adamant that they don't settle the case. So we found...
You shoot yourself in the foot.
Yeah, you shoot yourself in the foot. So we've found that it's best not to compel the defendant. Now, I do want the adjuster there, and if they don't have the adjuster there, I'm going to kick and scream, and we're going to file a motion.
Well, now, Chris, you're mostly talking about car wreck mediations,
Yeah.
right? My experience in employment mediations, in case you're an employment client, is that the defendant is often there.
We don't know whether they agreed, and that's important because later on, additional facts could be discovered through the lawsuit, or maybe the defendant goes to jail, or maybe something happens with your case that lowers or increases the value. We can go back to that number we were at during mediation, that high number, because that we didn't agree to in the mediator's proposal, and the defense can do the same thing. Is that making sense?
That makes perfect sense. What my clients have asked a lot, Chris, who's going to be there?
So at a typical car wreck, truck wreck, those type of mediations, even some employment ones, you're going to have for the defense, you're going to have the adjuster for the at-fault party's insurance and the defense lawyer. And on our side, you'll have the lawyer and the plaintiff, and then some people like to bring their husband or wife or boyfriend or girlfriend or trusted confidant, mom, dad, and that's all fine. We need to know mediation. If you have some concerns about the defendant being there, if it's a case where the defendant might be there, you got to tell us so we can deal with it. Absolutely. Something that I just thought of is there'll be times when the mediator may pull the attorney, Ray Fry, out of the room to discuss something with us.
Oh, that happens all the time.
Yeah, it's not that they're trying to hide something from you. I'm even trying to think of an example, but sometimes they just feel compelled to discuss things with us, not in front of the client. You can ask me what we talk in advance so we can let the mediator know, because often they provide a nice little lunch. But key is the defendant will not be there. And that pisses some of my clients off, and I get it. But it cuts both ways. I've struggled with the idea and thinking, I'm going to compel these defendants to attend mediation. But quite frankly, most of them don't have the authority to insist that the insurance company settle the case. And sometimes you'll have an adjuster who's standing. That's a pretty bloody, horrific thing to do, but that's what a trial is. Mediation, and I always say a good mediation may be one where you feel like you didn't get enough and they feel like they paid too much. Maybe that was a good result. Yeah, I've heard a lot of mediators say that if both sides walk away unhappy, then the mediator did his job right.
I've heard that too.
So a mediator is typically someone who used to practice law more actively, and sometimes they still practice law actively.
Almost every war and conflict that you can think of was won based on the information that was received through the scout. So I go to mediation to be on the scout, because in the event we don't settle at mediation, I may have learned something. I was able to judge the demeanor of opposing counsel, maybe his client if the client's there.
Yeah.
And I can use that information to help us win the war, because trial is a war.
Yeah,
it really is. And the object of a war is to kill everybody on the other side and have one of yours still.
We're talking about once every 5 years someone doesn't come to mediation, so don't think that you're the exception to the rule.
I don't think I've ever had a mediation without my client being there.
Yeah, it doesn't happen. It's just a point to be made, so you'll be there. Second, or next, I guess, is how long does the mediation take? And that depends. There are cases that I've mediated in 2 hours that we set for a 2-hour mediation. Often they are half-day mediation, so they go from 9 to be at mediation.
My client has to be in mediation. I'm a person that if you file this lawsuit, you sued these people, you created this situation, if I gotta be there, you gotta be there. That's just my rule. Now, are there exceptions to that rule? Sure. You're in the hospital, you're having surgery, you're, whatever, you got a really good excuse, we might try to reschedule the mediation. If it's impossible, we'll try to get an exception. But
send that to my office, and he will send it to the defense, and we will give a deadline to respond, say 7 days. If we agree to it, we sign it, I sign it, and I send it back to the mediator. If the defense agrees to it, they sign it and send it back. Now, if both sides sign, then it's settled for that amount. It's all done. If we sign and the defense doesn't, they don't know that we agreed to that, and vice versa. If they sign and we don't,
he's not our friend. That doesn't mean he doesn't like us or is not, or she is not friendly with us. What it means is she's not on our team. We got a team, they got a team, she's the referee, she's not on the team. And so you need to understand, and I get this question a lot, Chris, when's the mediator going to decide what this is worth? The mediator's never going to decide that.
Yeah.
This is not a judgment. This is a referee that is going to referee a negotiation.
First thing I want to talk about is dress code. What do you suggest for your clients?
Well, I want you to be presentable and clean. I'm very much of the person, you don't buy my clothes, so you don't get to tell me what to wear. I don't buy your clothes, so I don't get to tell you what to wear. But let me just tell you, everything about the mediation is going to be, they're judging your credibility, what you're like, and your clothes say a lot about what you're like. And so I want you to be comfortable and clean.
In the mediator's office, and we're going to start out in one separate room, and the defense is going to start out in another separate room, and the mediator may convene us in a bigger office or switch us around and bring us all together in one office, and we will do an opening statement where me or another lawyer from the firm will kind of give your position on the case, especially if it's a mediation that occurs prior to any discovery.
And so certain insurance companies, especially in car wreck cases, have a script that they have to follow, that they have to have 5 offers and counter offers, or else they're not even going to consider it a valid mediation. And I know that sounds like a game. It's not a game we're playing, but we have to participate in the mediation. We're not going to treat it as a game or make you feel like it's a game, but we are going to be aware of what our opposing counsel is doing and respond appropriately.
As opposed to a trial, but sometimes trial is the best option.
If we had a crystal ball and could tell you what was going to happen at trial, we'd be rich.
Yeah.
But the problem is, 3 things happen at trial. You get nothing, you get something, you get more than you thought. One of those 3 things is going to happen. You're going to get less than you believe it's worth, you're going to get more than what you think it's worth, or you're going to get nothing.
Get more money, or that your case goes to trial and you get less money, or that you get the case resolved and you move on with your life. I would like to add, I said that this means that it's happened after exchange of written discovery and depositions, but sometimes when your case warrants, the defense will reach out to us and ask for an early mediation. But for the most part, the same rules that we're going to discuss here today still apply.
That's right.
So first thing, and we've kind of compiled a list of questions that we've commonly encountered. First,
especially if it's court ordered, the court will order both parties to be there. If it's a malpractice case against a lawyer or a doctor, they're frequently there because they have malpractice policies that allow them to consent or reject the settlement offer. And so just depends on what kind of case you have as to whether the defendant will be there. We will know though, and we'll talk to you about this in advance. That's part of our preparation. It starts well in advance of we got to get out of here so I can pick my kid up at school. Come on. We can invest the time that is needed to give us the best shot at mediating.
Absolutely. And before we conclude, I want to talk about what happens if your case doesn't settle at mediation, because that's often the case. We've talked about the mediator's proposal, and that's a way that can resolve a case, but many times the mediator will continue to work the case. Just like we had to go to mediation for the insurance, just if you're at a mediation with one of our lawyers and there's no opening statement, don't take that as something's gone wrong. It just means that we weren't allowed to, or for whatever reason, and it's kind of a case-by-case basis.
Yeah.
I would add that once you give your opening statement, the defense is allowed to give their position as well. I've seen clients sit across from the defense lawyer and or the adjuster who's telling them how they're not that hurt and this, that, and the other, and they just get fuming mad. I used during mediation.
I was just going to say, during this moving back and forth chess game, I experienced, and I've been practicing 32 years, and my clients think it's a game. And it's not a game. It may seem like a strategy game, but it's not, and we're not going to treat it as a game. We have to do the moves, because if we could just walk in there and say, we'll take $500,000 and that's it, well, that's not immediately.
And they work to resolve a case. Now, their client per se is the settlement, right? That's their goal. That's what they want to accomplish. So with that in mind, they're not on our side. They'll be going back and forth, carrying the offers, and they'll come into our room and we'll discuss what the defense has offered. And I may say, you know, sir, can you please give us a second? Because
inappropriate. I don't want anybody to be distracted by what you're wearing.
Absolutely. In most circumstances, this will be the first time that the adjuster for the insurance company is laying their eyes on you. Often the adjuster asks the mediator, and we'll talk about this more in depth later, but often they ask if they can just simply come and meet you. And if you're sitting there in ragged clothes and you're not out of time, and she agrees to an extent, I mean, pretty much agrees with it, but just says, it's a necessary evil, you know, we got to stay up high for a while until it's time to start coming down.
That's true.
And again, it's not a game, it is a process that we must go through.
We're not trying to roll the dice, we're not trying to odd man out. We're trying to get you the most value that we can get today on the day of the mediation in the most ethical, effective way we can do it.
Yeah. So, Rafe, does your client have
prepared client and presentation of the lawyers? And whether you get to talk or not is not important. This is getting us prepared for ultimate trial unless we're able to settle this. And by the way, let me just say, this could be the end of your case if you settle.
Yeah.
You don't have to go to trial. You don't have to keep taking depositions or answer interrogatories, which you hate, and get calls from my secretary saying, we have to be in court next week, you know, on 3 days notice. Bottom line is, if you settle, because I care as much about what their opening is as I care about our opening.
Yes.
I want to hear what their perspective is.
So you want opening statements every time?
I want them more. I don't think it makes me settle the case, but I think it really signals to me what their defense is.
Yeah. Now, if you're a client and you're watching this video, do be aware that sometimes the mediator won't allow opening statements. Like if it's a 2-hour mediation, they're going to say, we don't have time for that. So I'm going to tell you, it's a mediator thing, I swear.
I can tell you what a lot of those are, in my experience. The mediator will come out here and say, look, I think I can get them to X number. Are y'all going to walk out? But I think that's as far as they're going to go. Well, he's testing the waters.
Yeah, good point. He's like, is your client really that insistent on Y amount? And play it as it is.
And we're not going to sell you out.
Yeah.
We don't want you to think we're out there making something.
Noon or 8:30 to 12:30, and sometimes the mediator will go over if necessary. And then we have full day mediations, and some of those I've even gone from 8 a.m. until midnight to try to get the case resolved. Because again, that is our best chance of getting the case resolved. And sometimes in a really big catastrophic case, it's 4 or 5 p.m. before we're even sniffing the possibility of a settlement. And patience. Hey, I once asked a mediator one time that I really respect. I said, much sums it up for mediation in a general sense, obviously.
Yeah, I just want you to come with a good attitude to the mediation, and it'll be a better experience for you.
I think that happened when I was a younger lawyer and less prepared and didn't prepare my client. But know that they're going to say stuff that pisses you off. Now that you know that, you shouldn't get pissed off, right?
Right. Well, on preparation, I think it starts way before the mediation. I'd like to encourage you to go watch our segment on knowing the medical, knowing your case, knowing your treaters, because nothing will be more persuasive than a well-prepared. This is not somebody's going to say this is what this is worth, but there are exceptions to that.
Yeah, the mediator's proposal, is that what you're talking about? Mm-hmm. So sometimes cases end in mediator's proposals, and we've spent however long the mediation is, and we're at a point where it just doesn't seem like it's going to get resolved that day. The mediator will issue a proposal saying that he suggests that the case settle for X amount of dollars. He will
strategy is, or what their case is about. Let me just tell you an example hypothetically. If you're saying that you got fired wrongfully and that you were retaliated against, and then in the mediation they go, well, what about those 95 absences you had last year? Mm-hmm. Wow, that changes the complexion of the day, right? Mm-hmm. And so we need you to be there so that you can feel the full impact. So this could be the end of your case.
Yeah, and oftentimes the court imposes mediation, and I know Rafe's the type, he would prefer not to go to mediation. I think he dislikes it to an extent, right?
Yes,
I don't mean to put words in your mouth, but I see it as sometimes as a necessary process. And that is because I've found that sometimes the insurance company policies and procedures dictate that the adjuster got groomed and you just don't appear well. They'll think, well, that's the way that person's going to look in front of a jury, and the value of your case just went down.
That's right. I don't think how you dress will help you settle the case, but it can absolutely keep you from settling the
I like
case.
that. I think that's right. So often clients ask too, do I have to say anything? I'll take that one.
Okay.
In some cases, we do what's called an opening statement at the mediation. The mediation is going to happen at a neutral location. Absolutely. That is so true. I mean, and I know some people that work on the insurance side that have come over to the plaintiff side that have told me that the adjuster was required to make 5 moves before they even came up to before they were allowed to extend their top dollar amount. So it's a necessary evil. Susan, that obviously of the firm, I remember I used to get so frustrated with mediation because I thought this is a waste of my adjuster to get more authority to settle the case. Sometimes we have to get closer to trial or let a fact or two more develop. Maybe they have to get some of your past medical records. Maybe they didn't properly evaluate the case when they came. That mediator will usually still continue to work on your case, still stay in contact with each side via telephone, text, whatever, and do his best to resolve the case. So don't think just because you're leaving a mediation and it's not resolved, telling them we're not going to pay more than, this amount of money, and he knows they've got more authority. So we're all kind of posturing to an extent. But the bottom line is the mediator's not our friend. So we don't say certain things to him. We don't give him our bottom dollar per se. And that's not every case. There are times where I say, look, this is what it's going to take, and that's it. And I mean it. And maybe we don't get it done, but at least they know that.
Yeah, and I want to add to what Chris is saying about